Firstly, I'd like to welcome Iain to our panel. Iain is a member of the firm's non-contentious construction team. He's got over 20 years of experience both as a solicitor in private practice and in-house for one of the UK's 10 main contractors. And he's advised on some landmark building projects as well as some major infrastructure projects. We're also welcoming Marcus today. Marcus is a construction and engineering disputes lawyer, and he's got a number of years' experience in resolving disputes concerning office, retail and leisure developments, as well as doing a little bit of work on social housing projects as well. And Marcus also has some international experience. Now, I appreciate that you may struggle to find a common theme between the two topics that we've decided to discuss today, that of impact of inflation and supply chain disruption risk and dealing with defects. And what I really wanted to say was that there is a common thread in that these issues that we're discussing have historically been, and they do continue to be, common themes in building projects. And whilst these issues are not new themselves, they do present different challenges against a backdrop of fast-changing and ever more complex economic, social, and political landscape. I'm going to unashamedly steal a quote from a presentation that I attended a week or two ago. It's a quote from a late 17th century poet, and he's called John Gay. What he said was, I know you lawyers can with ease twist words and meanings as you please. That language by your skill-made client will bend to favour every client. Now, I think the challenge today really is to see if Iain and Marcus, in discussing each of these topics, can show us, with a consideration of the issues in question and also some clever drafting, whether it is indeed possible to twist words and meaning to favour every client. I think if that's too big a ask, at the very least, Iain, as a non-contentious specialist, can help you not to fall into some of the most common bear traps. And with any luck, Marcus, as a contentious specialist, can rescue you if you do. So without further ado, I'm going to turn to Iain first, and we're going to discuss inflation and supply chain risk. So Iain, you've chosen to discuss what is a very hot topic really for the construction industry at the moment. But why have the current rise in prices and delays in delivery of goods become such a huge issue really for the construction industry?
Well, it's a good question really, Chrissy, because if you look at the historical background, nobody would have been interested in talking about inflationary risk or supply chain disruption in the period from probably 1990 until about 2016, because it was a very benign environment. Frankly, these issues just didn't arise. But since 2016 and the Brexit referendum, you're starting to see these supply side shocks coming through. Particularly, you've got Brexit, so there were delays at the borders there as a consequence of that, the friction there. Then with COVID-19, once again, you've got supply side risk issues, and also you can't simply source goods and materials, so that puts pressure on prices. And subsequent to that, we've also now had the war in Ukraine, or we haven't, the ongoing war in Ukraine. So there are three huge supply side shocks that have happened there. And what I mean by supply side shocks from the construction industry's point of view is all of these things potentially extend the time period in which it takes to deliver the project and get to completion. And it also increases the cost of the project because prices that you estimated a year before you commenced on site are just no longer a reflection of what's there in the marketplace at the moment. The Bank of England at the moment is estimating that we're talking about an inflation rate of peaking at between 10 and 13%. But if you look at the RICS surveys, if you look at the guidance from the Construction Industry Council at the moment, they're talking about an underlying inflation rate for construction of about 28%. And that's where we are at the moment. And that doesn't take into account spikes in pricing as well, which can be 100% for steel, 100% for timber. I mean, they go up and down very quickly, but you're still going to deal with that environment.
So effectively what we're looking at really is a resurfacing of a set of risks, which the construction industry hasn't actually had to consider in recent years. But why are these risks more of a concern for the construction industry than for any other industry? Or are we looking at a situation really where contractors are just belly aching?
Yeah, I mean, it's a very popular narrative to say we've got a belly aching contractor. They're moaning about all the risks that they've got to deal with. How much of it is really valid and how much of it is just smoke and mirrors to push the price up. So I fully understand that, but I do think that they have got a legitimate concern to raise at the moment. I mean, if you step back a little bit and think about what construction is okay, it's a product, but you're developing a bespoke product. It's not a manufacturing supply line for an aeroplane or a car or something along those lines. When you commission a building project, often it's, as I say, bespoke. It will contain innovative materials and products. It will not have the same supply chain as the previous product. So the contractor, the subcontractors will change every time. And the period over which the works are undertaken can be a number of years. So all of these supply side shocks that I was talking about need to be set against this background where you've got a lot of variables that you don't have when you're manufacturing another product, say an aeroplane.
Very convincing, Iain, but surely if the construction industry are particularly vulnerable to these kinds of risks, can't contractors just simply negotiate and draft contracts, or you can help them to do that, which transfer risk to their customers, to the employer, to the developer?
Yeah, I mean, in a fairy tale landscape, that might be achievable, but let's go back to what I said previously. Nothing has really changed in the last 30 years until Brexit on these two major risk issues. Everything has been very benign. Against that benign background, you've got an allocation of risk in building contracts that places inflationary risk, increases in prices of cost of materials, etc., all with the contractor. And just to illustrate the point, the conversation that we're having today is very much not about infrastructure projects. We're talking about UK-based building projects. So building projects for apartment blocks, also offices, that kind of thing.
Straightforward building projects.
Straightforward building projects. And those contracts are normally let, 75% in the UK statistically, are let on JCT design and build contracts. Of the remaining 25%, the vast bulk of those are let on JCT standard form building contracts. And those building contracts allocate these risks all to the contractor. So they agree the lump sum price, and the contractor takes the risk of any tax increases. The contractor takes the risk of any increases in products or material costs over the lifetime of the delivery of the works.
I can see the problem. Perhaps for everyone's benefit, can you give us some illustrations using this supply side shock issue that we've been talking about, where a contractor may or is likely to suffer as a consequence of JCT risk allocation?
Yeah, I mean, I don't want to go into a broad summary of what a construction contract does. I mean, it affects payment terms, it affects health and safety, it affects a number of issues. But one of the key points about a construction contract is it allocates risk. Now, we've already said that it doesn't really deal very well with inflationary risk or the increase in cost of materials, etc. But it does allocate some risk. And there are provisions in the JCT contract for additional time. They're called relevant events. You'll find them around clause 2, spot 26. You'll get additional money as well for relevant matters. And you can also get additional time and money if there's a change in the law. And why I've brought onto this the subject of risk allocation here is if you're talking about change of law, think about the Brexit shock that I was talking about earlier. So you had a situation there where there was a Brexit referendum, then there was the Act of Parliament for the UK leaving the EU, etc. That was a change in law. But then you look at the mechanism within the JCT contract, which allows for a change in the law for additional time and money. But it's only if it materially affects or alters the works. Now, just by us withdrawing, the EU Withdrawal Act doesn't actually materially adversely affect the works. So there wasn't automatically an entitlement for time and money there. So that's how it doesn't work. And the same position applies with COVID-19 potentially as well, because you'd be entitled to additional time for a force majeure event. But the contract's not great. JCT doesn't define force majeure events. I recall when I was working in-house for a contractor that you had a situation where you were waiting with Boris Johnson standing outside number 10 Downing Street, very proud of himself, saying that we're keeping Britain working, etc. When what the contractor wanted to happen was for them to issue an instruction saying that to close the site, because that would create a relevant event which would give them additional time for their project. That didn't happen. So it's not tailored to the risks. JCT as it stands is not tailored to the risks that we're talking about here.
I mean, from what you're saying, obviously the contractor's concerns are very real, but we've also got to appreciate that from a developer's perspective, employers' perspective, quite understandably, they need some degree of price certainty.
Yeah.
And it sounds like there is a bit of an impasse really between building, and we've still got building projects and starting and continuing to run. So how are these problems actually being resolved in practice?
Yeah, I mean, if I look out that window there, you've got cranes going up all the time. I mean, you can't just simply say, we are not going to build anything, we are not going to commission works until all of these supply side shocks and inflationary risks have gone away. So you are seeing strategies to deal with it. And some of them are borderline funny and some of them are fairly horrific, to be honest with you. I mean, just to give you an idea, what I see most of the time is you've got the kicking the can down the street strategy, which I'll go into in a minute. You've got this kind of inflexible strategy, rigid strategy on the part of the person commissioning, the entity commissioning the works, the employer, saying, no, JCT is what we're stuck to for all of these years. That's the way it allocates the risk. We're not budging. Then you've got the slightly more enlightened approach to dealing with it, which is an acknowledgement that Brexit has been a risk, that COVID has been a risk. So you will get a schedule of amendments to the JCT contract that will create allowances for time and money to be granted to the contractor, but that will very much depend upon the specifics of the Brexit risk. You need to tease out what exactly creates the entitlement.
That's sort of a bolt-on.
Yeah, it's a bolt-on.
Yeah.
That is exactly what it is. And to a certain extent, it's great, but it's retrospective. It doesn't look forward as to what's coming down the line in the future. And the last approach is the kind of approach where the employer has early engagement with the contractor and understands the risks fully, and then works out how they're going to manage those risks. And some of it might be practical management, and some of it might be legal allocation of the risks to those most able to manage them.
I don't think you have to be a construction expert to have an idea, but which do you consider the best approach? You probably all know, but
I didn't leave much to the imagination there as to where I was going with this. Obviously, the collaborative approach, the early engagement approach to dealing with these risks is the one that I would favour. And it's not just the one that I would favour, it's a CIC, Construction Industry Council recommendation to the industry to follow that approach. I mean, the horrific approach that I was talking about earlier, the one that bothers me most, is the kick the can down the street approach. And what I mean by that is, and I've seen it, everything is agreed on a construction project. So building contracts agreed, the terms are agreed, the schedule of amendments agreed, the employer's requirements are agreed, the contractor's proposals agreed. It's all done apart from the price. And then there's this dance going on between the contractor and the employer. And nobody will agree the price because nobody knows what the price for the works, for the materials is going to be in month 12 of the programme. So what happens is that you start on site under a letter of intent, where the parties continually, the works continue and continue and continue.
But mission creep springs to mind.
Exactly, thank you. That is exactly the words I'm looking for, mission creep. What happens there is that you get so far into the transaction and the contractor's on site, but you haven't got price certainty. The employer hasn't got price certainty, but they are to a certain extent the hostage of the contractor then, because you're not going to turn around to the contractor and say, stop, that's it, halfway through the project. So you end up paying a lot more than you would have done by kicking that can down the street. So that's the worst case scenario. Strangely enough, the inflexible kind of rigid approach from employers is not necessarily problematic. And why it's not problematic is if you've got a fairly straightforward building project, for example, what we call sheds, which are out of town shopping centres where you've got your B&Q shed, you've got your Toys R Us, that kind of thing. They're fairly straightforward in terms of building. So you haven't got long supply chains because if you're talking about concrete, steel, etc., you can source it all in the UK. You're not worried about things coming from China, etc. And you can probably plot on a graph where the prices of those materials and goods are going to go to. So to turn around and say, we're sticking with the risk profile as we've got it, is perfectly reasonable. The responses that you get back from the contractor, you choose the one that suits you most in terms of the best price and whether it's the best contractor to do the job. But it might make sense there. But if you've got that rigid approach and you've got a very bespoke construction project, for example, a high-end hotel development in Mayfair or something along those lines, you've got all of those moving parts, all of those different products that I was talking about. If you say we're taking none of the risk profile is as it is under the JCT agreement, the problem that you've got there is that all of your tender responses that come back from the contractors are going to price in that risk, and you could potentially pay more than you need to. I just did want to go back though. The other concern that you've got on this inflexible approach is that you pass all the risks to the contractor, they underprice it, they get the job on site.
And you sink your contractor.
Yeah, and you sink your contractor, because it is worthwhile thinking about this. The profit margins in a competitive market for contractors are 2 and 3%.
Yeah.
So it wouldn't take much in terms of supply side shocks or inflationary risk, prices increasing, where their profit's gone.
Yeah.
And they're diving.
Yeah, yeah.
And the idea of getting another contractor on afterwards to fix the problem, they are going to price that high.
Yeah.
So you will pay. You will pay for that strategy.
So this early engagement collaborative approach is obviously the favoured approach.
Yeah.
Would you like talk to us a little bit more about how you've seen that work in practice?
Yeah, I mean, the first thing I'd say about it, and the most obvious way of dealing with the collaborative approach, is at tender stage, looking at, if the first thing I think is getting the right contractor at tender stage and what tender process you follow. Because if you have got long supply chains and you have got a list of products that you think it might be difficult to source, you want to be looking at your contractor and knowing that they are established in the marketplace, that they have that supply chain security, which would reduce the risks in the first place. The next point about early engagement is that you perhaps want to do a two-stage tender process where you've got a professional services agreement between you and your selected contractor to work out the design on the project and also to work out the pricing. And that is a discussion process there, because you might select something particularly bespoke or sparkly, you know, Willy Wonka's glass lift or something like that in the atrium of your posh hotel. But it might be just too risky. They might turn around and say, well, if you want that, but the supply you're proposing is in China.
Yeah.
They lock down every 5 minutes for COVID at the moment. You might want to think about doing something else. So that's that kind of collaborative approach. And it's also the approach that builds up an understanding of where you get to the price.
Yeah.
And then you can move on after that and enter into the main building contract. So that's what I'm talking about in terms of collaborative, two-stage tender, professional service contract approach. I think that is a good way to go.
Yeah, and have you got an example of in practice project where you've actually seen it work, where it's been an effective tool, really? Yeah,
I mean, the most obvious one was when I was actually in-house for a contractor, and the contractor was speaking to the employer in this case, and it was a large central London apartment block. And as is popular at the moment, you've got prefabricated units that are slotted into these apartment blocks. So you had a pre-built bathroom that you would slot in, and they would all be loaded on a ship from China and sent over to the UK and then put into the building. The conversation there was, this is a long lead-in item, it's going to be manufactured on site. How do we deal with this? We don't want delays, etc. Order it early.
Yeah.
Order it early, okay, fine, how do we deal with that? Well, we put it in as a listed item in the building contract, which allows the contractor to get paid early for these prefabricated units when they're not brought to site, because normally you only get paid for goods and materials as they get brought to site. And there was a conversation there about basically making sure that the order early was okay, but also the employer was protected in that process. So there was a vesting certificate, there was an off-site materials bond to support and protect the employer, just in case that manufacturer in China became insolvent.
Yeah. So the cozy chat. I mean, we're not living in a fairy tale here, and I don't think
I'm
not going to let you get away with it that easily.
Yeah.
And the solution can't just simply be a cozy chat between the client and the contractor to discuss the risks, how best to deal with them.
Yeah.
And fundamentally, that doesn't change the contractual risk profile that we've discussed earlier. What are you seeing in practice? What are the mechanical tools, really, in terms of the contracts themselves that we're seeing amendments or ways to deal with this risk?
Yeah, I mean, the cozy chat is a nice way of saying the two-stage tender process to sit down And that's the concept. The cozy chat is about the risk. Then you move on to how you deal with that risk. Once you've decided that it's a real risk and not perhaps contractor bellyache, because you've explored the risk for a particular product, for particular materials, etc. And there are various mechanisms within the JCT contract that can help the parties reallocate these risks more practically. As I said, you might not need a legal reallocation at all. You can just change the product or change the source of the product during the discussion. But in addition, there are issues like listed items where you can pay for the goods in advance, so they're ordered in advance. That's dealt with at contract particulars. If you look at clause 415, 415.4, something along the lines there, you can elect to list items that you can then pay for early, but subject to those protections. You've also got provisional sums. So if you don't know how much at the moment a particular item is going to cost, you can put that item into the contract as a provisional sum, and then the employer can elect whether to instruct the use of that provisional sum, i.e. acquire that product or not, depending upon when it's needed, for perhaps in 6 months' time after the works have commenced. So it's kind of, it's not going to be a one-size-fits-all on the provisional sums issue, because you can't turn around and say all steel, all concrete is a provisional sum. But if you've got selected items that you might not know what the price is going to be, you can deal with it like that. Then there are these fluctuation clauses, which is pretty much get your flares out, because nobody's looked at them since the 1970s. And the drafting actually refers to some kind of things that are very kind of in place in the 1970s that don't apply now. But by fluctuation clauses, I mean clauses in a contract that allow the contractor additional time and money for certain events. Now, that can be increases in taxes, increases in cost of materials. Now, the JCT has standard form fluctuation clauses, as it has a standard form contract, and you can elect or not elect to adopt those. In the past, the standard position in the JCT contract particulars is that option A, I'll go into this in a second, applies unless you strike it out. And everybody has just religiously struck that out for the last 20, 30 years. That's not the case now. But you've got those standard form fluctuation clauses, which we'll go into. But you can also have a conversation following that two-stage tender process, that cozy chat, and perhaps have a bespoke clause drafted by your lawyer in the schedule of amendments to the JCT that will deal with the specific products or items and perhaps share the risk. So if they go up by 10%, you share half of the cost of that year, or decrease. I mean, I don't want to sound too pro-contractor here, because basically all of this advice that I'm giving now is making sure your product gets over the line for roughly the price you thought it was going to, and that there are no shocks. So you can get those bespoke clauses in there as well.
No, I didn't know. I didn't know whether you wanted to talk about fluctuation.
No, I don't want to talk about fluctuation.
I didn't think you did, but now that you have, and everyone's dusting off their schedules to their JCT contract and wondering what actually they say, I think a lot of people will be aware of the fact that we've got 3 fluctuation options in the JCT 7 contract: option A, option B, option C. Now, if you didn't want to talk about fluctuation clauses in the first place, I know that you're not going to want to talk about option C, but perhaps just give us a brief overview of the 3 options and when we'd be looking to use them.
Okay, right. So as I said, in the JCT contract particulars, you can elect which fluctuation clause you want. If you don't strike them all out, you end up with option A. And just going to option A, option A is a fluctuation clause that only really relates to taxes and levies. And they're taxes and levies on materials and goods, and taxes and levies on employment. So what I'm talking about there is, now this is an example, supply side shock, again, Brexit. I mean, the government changes every 5 minutes at the moment. And somebody upsets the Northern Ireland Protocol. We're suddenly in a trade war with the EU. We're back to WTO terms. Then if you've got a fluctuation clause A in there, you'll be able to look at that and go, well, this was the price and the tax that's paid on this material or good coming in from the EU at the time. Now there's 20% dumped on top. So you would then do an assessment on your payment application to reflect that fact. But I would emphasize on option A, like the other options, it also works the other way. So if things fall, the price will come down and the contractor's got to make the adjustment and make the payment application on that basis as well. And it doesn't include profit. So if prices go up and you get additional money for those increased costs, that's fine, but you don't get additional profit. You're not rewarding the contractor for increases in the cost in the marketplace. We're not talking about BP or Shell's profit margin.
Yeah.
You don't get a reward.
Yeah. I mean, option A, useful but fairly limited.
Yeah, useful but limited.
Option B.
Option B is the one that if you were a contractor that you would want, if you were an employer, you would handle with care and perhaps think about a bespoke fluctuation clause for specific risks, because it's much broader. Option B. Option B covers increases in taxes, but it also increases in materials costs. So you would put your tender prices in there that you price the job on for particular materials, goods, etc. Then you would look at the price of those materials as paid for. You would make an adjustment on the payment application and recover that. Once again, works both ways. So we're being told that these costs are supposed to peak and then drop. So perhaps if you enter into a building contract in month 6 of 2023, you might find out that those materials costs are, in an ideal world, you might find out that those materials costs are less 6 months later, and that will be reflected in the payment applications for those goods at the time. So I think that covers that off, really.
Yeah. You've neglected option C.
Yeah, I don't want to talk about.
Away with that?
I don't want to talk about option C. I'm going to tell all the viewers here now that I got a C in maths and just scrape that. I hate the idea of it, but it's really for the QSs and for the mathematicians out there.
I mean, it's a formula.
It's a formula. It's 60 pages of formula that basically you run through that formula to work out what the price will be. And there are numerous variables within the formula that arrive at that calculation. I cannot see anybody, I mean, this is a trend at the moment. We're only seeing a little bit of pressure for fluctuation clauses. I can't see us moving to everybody demanding fluctuation clause C straight away. I can't see it getting there. And frankly, everybody's going to have to read it and understand it before they even start asking for it. But option A, option B, I can see that pressure building up.
Okay, I'll let you off. I'll let you talk.
That's very kind of you, Chris. It's the first time you've been kind to me.
So I think in summary, really, what effectively you're saying is that in order to manage the current supply chain and inflationary risk, the clients are best advised to do 4 things. And by all means, jump in here if you haven't missed anything out. You're saying consider the risks early. That's the common sense approach. The second thing is obviously to appoint a really good professional team, including a project manager and a lawyer who can identify inflationary supply chain specific risks specific to your project and then help you with mitigation strategies. And the third thing is this enlightened and collaborative approach that you've talked a lot about. And then finally, make sure that whatever the contractual mechanisms that you do agree and adopt, allocate responsibility to the risks that you identify and they actually work in practice.
I think the one that I didn't really cover off when we were discussing this subject was the need for a good PM, good project manager, to steer that procurement process at the outset. If they are familiar with the kind of work that you want to do and the nature of your project, then they will be able to save you a lot of time and money in the long run. It's important to get the right guys on board, guys or girls on board. In relation to that.
And I think actually having a really good professional team is something that runs through sort of the whole theme of today, really. And I know that Marcus, you're going to talk about that in relation to the defects position. So thank you, Iain, very much. It's a really helpful overview of the key risks really the market's facing at the moment and how in practice we're trying to help and deal with those and push projects forward. Because as you say, everyone wants things built on both sides. It's just a question of coming to some kind of collaborative approach to keep the wheels turning. Marcus, we're talking about defects today with your as a contentious lawyer. Defects, of course, are a major source of disputes on construction projects. We're looking at arguments as to whether it's something a defect in the first place, the requirement for a contractor to rectify defects, what a latent defect actually is there a duty to warn about defects in other parties' work, a whole range of issues really that rear their ugly heads in relation to defects on construction projects. Understand that today you're going to focus on defects-related issues in relation to JCT D&B contracts. I think it's important to point out to everyone that there are obviously huge number of different construction suites available in the market. NEC, we've got FIDIC, usually used on international contracts, obviously. Can you just briefly explain the reason for the focus today on JCT D&B?
Yes, two reasons. The first is, as Iain mentioned, it's the contract that we see the most often, certainly the JCT suites. And the second reason is really to simplify the purposes of today's discussion, because under the design and build contract, the liability for design lies with the contractor. So there's no need to have to separate a defect that's been caused by design and workmanship. So the liability is there in one place.
Yeah, sure. And I think just going back to the basics as well for a second, most people will know that there's no common or universal definition of a defect, which makes your life obviously more complicated from the get-go. But for everyone's benefit, can you briefly explain what a defect actually is, what we're looking at?
Yes. So somebody calls or emails me with some horrendous pictures of cracks or something like that, and then says to me, Marcus, I've got a defect. Yeah. So one of the first things I'm looking at is well, how does that fall within the contract, within the obligation? So a defect can usually be described as an element of design or construction which falls short of what should have been supplied. Yeah. So in terms of a defect being a breach of an express term, it might be a failure to use anything specified by the employer's requirements, a use of materials prohibited by the employer's requirements, workmanship or design not in accordance with the contract, and then outside of the express terms, we might look at implied terms, so a breach of supply of goods and services act, something like that.
Sure, and I think defects is something that people commonly associate with post-completion, so your defect rectification period, but actually that can be a little bit misleading, I think, and it is something that needs to be thought about and discussed between client and professional team during the construction phase itself. Is that something you've got views on sort of dealing? Is it easier to deal with them early on, nip it in the bud before we get to defect rectification period? Is that
it is
practical experience?
And it is, and it feeds into what Iain was saying about getting your professional team lined up from the outset, really. And the reason why you can instruct the contractor to open up. Now, who's best placed to instruct the contractor to do that? Somebody who knows what they're talking about. Yeah. And that's going to be a well-appointed and properly appointed contract administrator or employer's agent. And you mentioned cost, because an employer's agent typically charges somewhere between 5–10% of the contract value for their fees. And often parties will look at that and say, well, that's a fee I can save or at least reduce by reducing the scope of what they're employed to do. Yeah. But really what you want is a well-appointed contract administrator who's there to inspect regularly, to inspect for quality, a positive obligation to inspect for quality, as well as being involved in valuation with your quantity surveyor. And look, it's not for me to criticise the way that people run contracts, but we do see that. We do see employers' agents with very limited scopes, and then unfortunately things do slip through the net, and they can manifest themselves later down the line, sometimes years down the line, when it becomes all a lot more complicated. Maybe the contractor's insolvent by that point. So if you've got somebody on board who, as I say, is dealing with and instructing the contractor to open up, to look for defects as the works are being progressed, then it is, and it can really assist. Yeah.
So, I mean, effectively what you're saying is that defects are something we should be thinking about, not only from PC, but also during the lifespan of the project itself. I think it's quite important to look at PC itself before we move on to talk about defects and rectification periods, the 12-month period following PC, because getting PC in the first place, there are sort of things that you need to think about around defects at that stage as well, aren't there?
Yes, and often people are perhaps quite fairly desperate to get to PC because the contractor doesn't want to be paying any delay damages. An employer wants the use of their building, but it's important just to take a look at PC. It's not a defined term in the JCT suite of contracts, and it's a question of fact. So if you'll forgive me for just referring to a court judgment here, which discussed for PC to occur, that the employer is able to take possession of the works and use them as intended, but not completion down to the last detail, however trivial and unimportant. So what does that mean? It means practical completion can be given where there are minor defects that then can be dealt with at a later stage. But What it doesn't mean is that you can get PC where there are incomplete works. And I do want to draw that distinction, because there does seem to be some confusion out there that essentially you can say, well, the works aren't complete, but what is not complete is quite minor, therefore we can practical completion could occur. It can't. If you've got minor defective works, then yes, you may be able to have practical completion, but not if there are works that simply are not done.
And so we get our PC, the corks are popped, everyone is delighted, and then we move into our defects rectification period, typically a period of 12 months. Now, this liability situation in your defects period of 12 months, that is not a one-stop shop for liability, and I think you'll go on to make that clear. And that's not a one bite of the cherry to get everything right. We have got limitation periods. You want to just talk a little bit about the interplay really between general liability and limitation periods and what you've got in your defect rectification period?
Yes, so as you say, the defect rectification period, I mean, you'll have discussed that with Iain when you've been negotiating the contract, but 12 months is very typical, but I have seen shorter periods. And the liability point that you raise is important, because I have had situations where parties have understood that liability lasts as long as the defect rectification period, so say 12 months, but that's not right. The liability will be 6 years if you've signed it as a simple contract underhand. If you've executed the building contract and indeed your appointments as a deed, then the liability period will be 12 years. What the defect rectification period dictates is the relationship between the parties during that period. So for any defects that appear within that period, it's for you as the employer to say to the contractor, I have identified this defect, and it's for the contractor to repair that defect in a reasonable period of time and at no cost to you, the employer. And it's important because what you'll want to do, ideally, from an employer perspective, is if the contractor does not carry out that repair, then it's only at that point you can instruct a third party to do it. You've got to give the contractor that opportunity. If the contractor fails to do it or refuses to do it, then you can instruct a third party to do it. And if you're incurring sums with a third party, ideally what you want to do is be then deducting that sum from the final account or retention, or you may end up chasing the sum, as it were, as a debt, but you really want to be doing it, reducing it from money you've already got control over, rather than trying to recover a sum.
And then you've drawn this distinction with liability in the 12-month defect rectification period and your limitation periods under the actual contract. I think another distinction that it's quite important to draw here is between latent and patent defects. Latent defects being an inherent defect, something that's understood in the general market, but maybe it is something that people struggle to get their heads around. Can you just shed a bit more light on what we're actually talking about when we're looking at latent defects?
So a latent defect is it means a defect or an imperfection it's there, but it's not visible. We don't know about it, and it's not reasonably discoverable at handover. It's probably something within the core of the building or hidden behind some decorative element. And typically, a latent defect will be discovered or manifest itself later down the line. So to give you an example of how we often find latent defects, if you've got a water leak that requires some sort of intrusive investigation, some layer of plasterboard to be removed, you will often find, for example, that fire stopping or insulation has either been fitted poorly or in some cases not at all. And it's that sort of defect that you will identify because of the water leak that's caused you to remove some paneling.
Now, moving on to sort of defences raised when we're looking at actual defects claims, in my experience, we often see, I'm sure we'll have seen this as well, we often see contractors raise the defence that PC's been signed off, that's great, by your contractor, your contract administrator or your employer's agent. The defect was not disputed at PC. So why is there an issue now? Is that something you commonly see, and is it something that worries you?
We do often see it as a defence raised by a contractor. They say, as you say, well, building control signed it off, your employer's agent signed it off, or they signed off the period of work, whatever it may be, they gave full valuation for it. it's a pretty sort of low-hanging fruit argument to deal with. I'm not usually too concerned when it appears. If a defect is there, then a defect is there.
That's not one to give you particularly sleepless nights. Obviously, non-detection is not the only string in the contractor's bow in terms of its defects armory. What does give you a sleepless night? Where are we worrying here?
What does concern me a bit more, often repair and maintenance. So let's say you've got lifts that are defective in some way, then it's really important when a contractor raises maintenance and repair to be able to say, and what they're basically saying is, the defect has arisen because you have not looked after the building that I've built for you properly.
Yeah.
Follow the O&M manual.
Follow the O&M manual that you will have been given at PC. When we say follow it, don't just chuck it in a drawer or leave it hidden on a hard drive that then gets corrupted. Use it. Be proactive about your building maintenance and keep a log of what you've done. And this is particularly important where you've got a portfolio of buildings, because sometimes you end up with a situation of the owner of that portfolio has a bit of a one-size-fits-all approach to repair and maintenance. And what we want is bespoke maintenance, so that we can show to the contractor very readily, yes, we maintain the building, and here is my log to demonstrate that.
Sure. Now, I know that Iain didn't want to talk about fluctuation options, but I was mean and I made him talk about it anyway. So, and I know that you're not going to want to talk about the Latent Damage Act, which obviously drawing legislation into today's discussion, but I think it is quite pertinent that we do just touch on it today, especially given the legislative developments we've had this year in relation to the Building Safety Act and sort of interaction or the interplay between those two pieces of legislation. Can you just give us a brief summary really of how that interplay works in terms of liability periods?
Yes, so the Latent Damage Act effectively extends the period that you might have to bring a claim. And it gives you the right to bring a damages claim within 3 years of the date of knowledge of material facts concerning damage, and the right to bring action in respect of that damage, and it's subject to a 15-year long stop date. Now, the reason it's quite a complex area of law, it very often requires expert evidence, and that's because what you're looking for is for somebody to give an opinion on a date when a negligent act took place, and you're often talking about a negligent act from years and years ago. And that's why it gets quite complicated. Yeah. But as you say, it's really pertinent. The Building Safety Act of this year has, in certain circumstances, extended the liability period to 30 years. And we're already seeing claims and considering position for clients to bring claims with that extended long stop period.
So if there is a defect and someone brings a claim, a successful claim, I think the damages position that people would expect is actually slightly different in practice. Can you just give us an idea of what kind of monetary compensation, if that's even the right word to be looking for, what is it? What can you expect in relation to a successful defects claim?
So assuming we've got over the liability hurdle, the sum of money you'll be seeking is the sum of money to put you in the position that you would have been had the contract been properly performed. So it's forward looking. If you've got defective glazing, for example, it's not the damages you will be seeking. It's not a refund. It's not looking at what the glazing cost you in the first place. And we've heard Iain talk about inflation, so that's important.
Well, it's going to cost you now or in a year's time, which might be substantially more. So
exactly.
That could create a certain element of a contractor going in and actually agreeing to go in and repair, as opposed to fight the claim.
Yes, it will be nice. Yes, it will be, because the contractor won't have a margin to worry about, the original contractor in that sense. So it's forward looking. So the cost you'll be looking for in that example would be the cost of repairing, replacing that glazing.
And do I, as an employer, is there an obligation to mitigate those losses?
Yes, you do have to mitigate your losses, and the court can reduce your damages if you haven't. And a really straightforward example of that would be something like a water leak, because if you've got a water leak from somewhere in the building, it's very likely that if it's not remedied quickly, that it will go on to cause further damage to other parts of the building. So in that case, what you want to do is carry out a prompt repair, and also to get in touch with the person that you think is responsible for that defect and say, this is what has happened, this is what I've done about it, I've done that in order to mitigate my loss, and now I seek a resolution. Yes, absolutely.
I'm going to slightly put you on the spot now. What does an ideal defects claim look like when it comes across your desk? What are you looking for? What do you want from a client? Where's the perfect package of information in this fairy tale world that Iain wants to live in?
Well, if I'm going to join in that fairy tale world, but from a contentious side, then I hope you'll forgive me for referring to another construction practitioner who once said that a party to a dispute will learn 3 lessons, often too late: the importance of records, the importance of records, and the importance of records.
True.
So what I really want to see is a whole stack of paperwork, thousands of files for me to look through, and I do have to emphasise that in my experience that has been entirely correct. I've had clients that have said to me, Marcus, I want to bring a claim for a breach of contract. I want to bring a claim for a breach of a collateral warranty. And I say, well, great. Let's take a look at these contracts and the collateral warranty. And they've said to me, oh, well, I don't have the contract and I don't have the collateral warranty, but I'm confident this is what it said.
Yeah.
And in those cases, it might not actually be a showstopper in terms of bringing a claim, because it may well be an implied term, but that really is a secondary position. And another important point is cost.
Yeah.
In that respect, because where you haven't got files and records, I really will be going hard looking for them.
Yeah.
And it does bring back up a pretty painful memory for me of spending 3 days in a windowless room at the storage facility on behalf of a client of an insolvent contractor, where we were looking for contract documents. It was me, 3 paralegals, 3 days, windowless room, trying to find documents. Now look, on that occasion, we found virtually everything we were looking for, and we actually got a really good result for the client. But it was significant expense incurred just in that exercise.
Now, there's some good news for you, which is that we're actually running very tight on time now, and also because you answered the Latent Damages Act question so nicely, I'm not going to make you talk about adjudication today, and we can save that for another time.
That's very kind.
But I think before we type and take some questions, I think it would be really helpful for everyone if you could just give us your 5 top tips on dealing with defects claims, so bringing together everything you talked about today and just in one place. So your 5 top tips. My
5 top tips, and really going through the life of a building project, would be to say carry out early due diligence. Be very alive if you're working with a contractor who's carrying out work on the land that they've purchased, and perhaps you're entering into some sort of joint venture with them. Look very carefully at the environmental and ground condition reports about the condition of the land and who they owe liability to. You want to be talking to Iain about that at the outset, and not me 2-3 years down the line. Retain control over your consultants and your subcontractors. Again, talk to Iain about collateral warranties. Make sure that those appointments are well drafted and that they're tight and executed as a deed to benefit from the 12-year limitation period. The third thing, going back to what I said earlier, consider a contract administrator and have them appointed with the scope of works to include inspecting for quality. It will give you another avenue. In case you've got an insolvent contractor, you may be able to look to the employer's agent. If you've got a defect and you're still in the period of negotiating the final account, try to have a final account that takes account of that sum that you think might be involved in the defect. That might be a bit optimistic, but I would try and do it if you can. To repeat what I said a moment ago, records. Please keep them, please retain them in some way, and do use them, and use the contract during the life of the construction, the build phase. And if you'll forgive me for giving a 6th one, because we didn't get to talk about adjudication.
We are tight on time.
I would just say on the adjudication, it's a very fast-moving process. It's 28 days in short. So, and it's no defence to say I wasn't ready for the adjudication, and the adjudication decision will be binding on you. So if you think you are at risk of an adjudication, talk to me. Ideally, you get your ducks in a row early, because it's really fast moving.
Very succinct and good summary of putting everything together that we talked about today. Now, I am conscious that we're tight on time, but we have had a few questions through, so we'll do our best just to answer, take a few questions, and then obviously if there's anything further you'd like to discuss, please do contact Marcus or Iain directly, they'll be more than happy to talk about anything that they've discussed today in further detail with you.